I think we're now ready to resume the hearing in the appeal of the test claimants in the French Investment Income Group litigation against HMRC. Mr. Ewart.
Thank you. Good afternoon, my lords. I was, before the short adjournment, I was just dealing with the question of the remedies available to the test claimants in relation to time value claims, particularly for the SEMPRA period. I thought it might be useful just to go back, if you like, to basics. The way in which the test claimants seek to bring their claims, going back more than 6 years, of course, depends, or has depended so far, on the application of Section 35(1) of the Limitation Act. And this in turn depends upon the claim in question being a claim for relief for the consequence of a mistake. And of course, this in turn requires the mistake to be an essential element of the cause of action, and not simply a background fact. And that was decided by this court in the first FII decision. Now, the only remedy which has until now been identified as fitting the bill is a claim in unjust enrichment for mistake. However, the result of Prudential is that that remedy does not exist and has never existed in relation to claims for time value. For the reasons spelt out in Prudential, as explained succinctly by Lord Reid this morning from the bottom of the ocean, it seems. But essentially, because what the claim was for, on analysis, was that the damages or the restitution had not been paid. In other words, the claim, the unlawful tax had been paid, but had then been returned either by way of set-off or by way of repayment before the claim was made. And therefore, what was really being claimed for was the fact that it hadn't been paid. It was analogous to a debt not being paid on time. And that did not result in any transfer of value. It wasn't an enrichment in any sense at the expense of the claimant. And therefore, there was no claim in unjust enrichment for that time value. Now, of course, the difficulty mentally in all this is that for a number of years, everyone has assumed there has been a claim in unjust enrichment in mistake for that period, because SEMPRA said there was. And we've spent a lot of time debating these matters on the basis that that was the law, but it wasn't. And we have to put aside, in thinking about this, any idea that there was or should have been a claim of that type going back more than 6 years. There is no EU requirement that claims go back for any particular period. There is quite a lot of jurisprudence about time limits in EU law. The result of it all, and I'll show you something later on this afternoon from the European Court decision in this case, in the third reference. But in summary, European law doesn't have anything to say against time limits, reasonable time limits, which have been set reasonable time limits which aren't being removed or changed retrospectively without a transitional period. And that was the problem in the third reference. I'll come on to that. But in general, reasonable time limits are permitted. 3 years has been held to be a reasonable time limit. It could be shorter, but at least 3 years has been held. And certainly 6 years would be a reasonable time limit. So this whole debate has to be, I would submit, conducted on the basis, putting aside from your mind these mistake claims that don't exist, going back to 1973, and asking, well, what claims do exist? Is there any claim in respect of it? And if there is a claim, is there a reasonable limitation period? And we would say, as regards the Section 85 claim that has been enacted by Parliament following Prudential, that it is perfectly compliant with EU law. It has a reasonable limitation period. It goes back for 6 years or back to 1996. The earliest claim in the GLO that we're aware of is in 2002. Most of the claims are after that, 2003 and following. Some of them as late as 2008, I think, or 2009 possibly. And therefore, as regards most of these claims, this is a fairly generous limitation period. However, as I've shown you, Your Lordships, Section 85 does not in any way exclude any other claim which might exist. The test claimants suggest that another possible way in which a remedy might be provided would be by way of a conforming interpretation of Section 35A of the Senior Courts Act. And perhaps we could just turn up Section 35A at this point. It's in Authorities, Volume 1, Tab 6. It's EF 3230. And subsection 1 is the heart of it. Subject to rules of court, in proceedings before the High Court for the recovery of a debt of damages, there may be included in any sum for which judgment is given simple interest at such rate as the court thinks fit or as rules of court may provide, on all or any part of the debt of damages in respect of the judgment is given or payment is made before judgment, for all or any part of the period between the date when the cause of action arose and the date of payment or the date of judgment. Now, the question here is, would giving a remedy for the time value period, the SEMPRA period, providing a conforming interpretation, would that go with the grain of the legislation? The principles regarding conforming interpretation are set out authoritatively in Vodafone 2, which is in Authorities, it's Bundle 7, Tab 80, EF 5751. And you might just want to look at that very briefly. The important passage begins on page 5750 and continues on 5751. And it's particularly paragraph 38. The only constraints on the broad and far-reaching nature of the interpretive obligation are the meaning should go with the grain of the legislation, be compatible with the underlying thrust of the legislation, and an interpretation should not be adopted which is inconsistent with a fundamental or cardinal feature of the legislation. So this would cross the boundary between interpretation and amendment. So those are the well-known principles that are applied. Now, it's first of all, we would submit a cardinal feature of Section 35A, that it is provided as ancillary to a principal claim for debt or damages. Now, if it is to be applied in the present case in relation to the SEMPRA period, then it wouldn't be being applied as ancillary. It would be providing, in fact, the principal claim. You may recall, those of you who have had the misfortune to have to read SEMPRA, that was a point that Lord Nichols made, and maybe some of the others, Lord Nichols made in SEMPRA, that what he was providing was not ancillary. It was the remedy he was said existed was not an ancillary remedy, and indeed that was the reason that he said it didn't conflict with Section 35A, because it was in fact the principal remedy, and Section 35A was all about ancillary remedies. The second cardinal feature is it is at the discretion of the court whether interest is awarded and at what rate and for what period. That, we would submit, does not appear to be a suitable provision to provide a freestanding remedy required by EU law. So the conforming interpretation in this case would have to, first of all, remove the requirement for a claim for debt or damages and remove the discretion of the court and replace it with something as yet unidentified. So for these reasons, we would say shortly, we don't see that Section 35A would be a suitable candidate for a conforming interpretation in order to provide a remedy for the SEMPRA period. We also say, even if it were possible to rely on Section 35A, any claim under it would have a 6-year limitation period. And that's expressly provided for in Section 9 of the Limitation Act. There'd be no question of an extended limitation period under Section 32. Because it wouldn't be, mistake would not be an element in the cause of action. It would simply be, I'm sorry, yes, Lord Sales.
Well, I just wonder whether there was an additional argument that you're seeking to make in relation to whether a conforming interpretation of Section 35A is appropriate. Are you saying as well that if Section 85 provides an appropriate remedy, that removes the need to provide a conforming interpretation of Section 35A because Section 85 meet the EU right?
Yes, I would say that. Yes, I'm sorry, my lord. Exactly, that would be precisely a point I would make. Yes.
And just on that, what do you say about the fact that Section 85 comes in quite late in the day, whereas Section 35A has been there throughout?
Well, first of all, there's obviously a reason for that. Section 85 was only enacted when the problem identified by Prudential was realised, of course. And it would be certainly true that if you had been seeking a remedy 10 years ago, you could have brought an action based on Section 35A, or you could theoretically try to bring one and ask whether it could be conformed. But now that there is a remedy, which seems to cover virtually all the ground that Section 35A would cover anyway, since it's a remedy for 6 years or indeed longer. The only difference might be, and it might depend on how the discretion was exercised, what the rates of interest were. We don't know what they would be under this conforming interpretation of Section 35A. But apart from that, it does seem to cover all the ground.
Yes, thank you.
What about the temporal limitation to 1996 onwards?
Sorry, Lord Reid, sorry, I couldn't quite hear.
I'm wondering about the temporal limitation in Section 85 to the period to payments made on or after January 1996. Because we're here concerned with payments going much further back than that.
Well, we're only concerned here because the claimants were bringing claims in unjust enrichment on the basis of Section 32. Yeah. You see, we're only concerned that this was really my first point, which was I think you should put aside the idea that we're concerned with these payments. So they did exist, but there's no reason why in EU law why there should be a remedy going back indefinitely.
Yes, I take that.
Yeah, this is my point about reasonable limitation periods. EU law is happy with reasonable limitation periods. So it wouldn't be necessary to provide a remedy indefinitely.
Mr. Hewitt, can you hear me?
Yes.
Can you just assist me with how the limitation period imposed by, I think it's Section 9, works in relation to Section 85? do you get 6 years from when the section is enacted, or might you be statute barred before the section even becomes law because your claim relates to a period more than 6 years before it was enacted?
Well, if we're reading section 9,
Yeah, well, yes.
It's the date on which the cause of action accrued. So the cause of action would presumably have accrued in this case. Well, I suppose from date, difficult to tell exactly what the cause of that, but it certainly had accrued by the end of when the set-off took place. You may say it accrued day by day during the period after the unlawful tax was paid.
So Parliament can be said, can it, to have legislated for a statutory cause of action, which, insofar as it was complete more than 6 years before the legislation came into force, would already be statute barred, even if somebody had rushed to issue his writ the moment he got the section from the Queen's printer.
Yes. Sorry, we're looking at section 9 as to whether,
Well, yes.
If section 35A had been brought in later, then
I'm not looking at section 35A. I'm looking at section 85.
Yes. And
which just remind me, when did section 85 become law?
It was sometime it was in the Finance Act 2019, so it would have been.
Yes. I mean, it seems prima facie a little odd. It seems prima facie a little odd that for about 2/3 to 3/4 of the period contemplated by a claim based on payments made after 1996, that a party could be statute barred even on the day it discovered it had a right.
I'm not. I wasn't suggesting that. I'm sorry, that section 9 with a limitation period in relation to section 85.
Oh, I'm so sorry. I've misunderstood you.
I think what I was saying was if the test claimants identify section 35A as an alternative, as a possible basis of claim, and my point there was if section 35A was a basis of claim as conformingly interpreted, then the limitation period on that would have always been section 9.
But on the assumption there is an ordinary limitation period for a claim under section 85, time wouldn't start to run before the Act came into force, is that right?
Well, section 85 provides its own limitation period because it provides that it applies to payments made, all payments made after 1st January 1996.
Well, however many 100 years it takes before somebody issues a writ.
Well, yes, that's subsection 1.
I'll be right.
No, because they can't. It only applies to claims made before 2012.
No, I'm sorry. Yes, yes.
But yes, anyone who brought a claim, let's say some claimants brought a claim, let's say in 2008, they would be able to claim under section 85, going back to 1996.
Yeah, I see. Yeah. All right. Thank you.
Yeah. So sorry. My point was, well, they even if they establish a claim under section 35A as given a conforming interpretation, it would still, we would submit, be subject to a 6-year limitation period, and would always have been subject. Presumably, the theory would be section 35A would always have had this conforming interpretation ever since it was enacted, and they could have brought claims under it at any time, but it would be subject to a 6-year limitation period. And so we can't at the moment identify any other possible basis of claim under English law, and so we would say section 85 is the basis, and there's no doubt they have a claim under section 85, whatever, because it has been enacted as statute. The only question is there some other basis of claim that they can identify? So that was all I was proposing to say about conforming interpretation, unless there's anything else the court wants me to deal with. I will show you the point about limitation periods when we come to look at the judgment in the third reference to the European Court. Can I then just move on very, very briefly to deal with the summary judgment appeal? And we deal with this in our first written case at paragraphs 100 to 101. Now, these summary judgments were granted to certain claimants within the GLO by Mr. Justice Henderson. They were only in respect of FID claims. And this was because he believed that the FID issues had all been decided with no possibility of an appeal or anything changing them. Can I just take you there briefly to his judgment on the summary judgment issues, which is in Core Volume 2. It begins at page 703, which is EF 1417. And I can perhaps take you immediately to paragraph 82, which is on EF 1445. So paragraph 82, you can see Mr. Justice Henderson says, there's one aspect of quantification, respect of which I'm satisfied it being appropriate to grant summary judgment. That is the claims for restitution in the form of compound interest for the period after utilisation or repayment of the relevant ACT. And then he goes on to say that's because that issue is still under appeal in the FII proceedings, and he had granted permission to appeal himself to the Court of Appeal on it. However, so what happened was the judge gave summary judgment on the basis of the law as he understood it to be at that time. And he didn't give it in relation to any issues which he concluded were still live in the proceedings. So that's why he only gave simple interest on the secondary periods. However, he did give summary judgment on the basis, first of all, that SEMPRA was the law, unsurprisingly at the time, and that DMG was the law. So he gave it on the basis of compound interest for the periods of prematurity, the SEMPRA periods, and he gave it on the basis of a limitation period going back beyond 6 years for those claimants to whom that was appropriate. And that was because he felt it was sufficiently clear to rely on House of Lords judgments and giving summary judgment, which I guess normally one would feel that was reasonably secure. These summary judgments have been appealed and are now before this court. But in fact, the two bases that I've mentioned have now been falsified. The SEMPRA and the DMG as a result of the judgment that this court gave a few weeks ago. And so the position is that the summary judgments we would submit should be set aside, and the claimants who have got the summary judgments will then get whatever they're due under their claims in the normal way. They're not going to lose anything. They'll simply have to prove their claims and get what they're entitled to, depending on the result of this decision, and depending on the result of the limitation issue, which I think this court has remitted back to the High Court. But we say the position is quite simple, that they shouldn't be any better position than anyone else in the GLO in relation to their FID claims. It's only their FID claims, of course. All their other claims are still stayed and will be dealt with on the basis of the law as set down by this court. So that is the simple position that we say that the simplest route is to set aside the summary judgments. The matter will then go back to the High Court in the normal way. We're expecting, subject to the issue about limitation, depending on what your lordships decide in this after this hearing, that we would be able to do the computations. The computations have been done, of course, for many years, and determine how much restitution each of the claimants, each of the groups are entitled to. But it wouldn't be appropriate to leave the summary judgments where they are. I think one of the points the claimants make, or might make, is when you work out how much they're actually entitled to, it's very similar in amount to the amount they receive by way of summary judgment. Now that may or may not be right, but it's not a reason for retaining the summary judgments, we would say. The other point is that there have been various minimum values agreed with claimants. They were agreed on the basis, as I understand it, that the revenue had won on limitation and on prudential, and on any other points that were still open. So it was the bare minimum. It's a minimum possible that there will be no argument about, even on a 6-year limitation period, and no recovery for prudential in restitution. But they have nothing to do with this. They are, the claimants may get more than that, of course, depending on how things work out. But that was a recognition of that being the bare minimum that they were able to claim. So, unless again there's anything further the court would like me to clarify, I was proposing to move on to issue 17. Issue 17 is an issue which arises in relation to ACT, payments of unlawfully charged ACT. And I wonder if it would be, I think it would be helpful if I was to set out what I see as being the steps in the argument. Now the first step is this, that this proposition, that as a matter of UK domestic law, where there is no ACT payable in respect of a dividend, then the dividend does not carry a tax credit to the shareholders. And that was the point that was decided, we would say, in Pirelli. And I will come back and look at Pirelli. But that was regarded as being a fundamental point in Pirelli. The second stage, so that is, we would say, the UK domestic position. The response to that, the claimant's response to that is, that's not the position as it regards EU law. So the second stage is, we would say, we would submit this, the conforming interpretation given to section 231 by the Court of Appeal in the first stage does not help the shareholders in the present proceedings claim a tax credit. What it does is provide an EU credit, an EU tax credit, to nullify any unlawful charge to ACT. And I'll explain what I mean by that, but that's what it does. And that, we would submit, is all it does. So that is a response to the arguments that the claimants have put in their written case, that the availability of credits has already been decided. The third point, the third stage of the argument, there is no requirement under EU law, we say, that the UK should provide a shareholder tax credit in respect of every dividend which is linked to dividends from EU companies. We say there can only possibly be such a requirement where a tax credit would be provided in a comparable domestic situation. And we say there is no comparable domestic situation in which a tax credit is provided. Again, I'll explain why we say that. Then, having put aside the European law objections, we would submit, as a matter of English law of unjust enrichment, a defendant is not necessarily enriched by the face value of a money payment which it has received. And that's because in assessing the enrichment of a defendant, it's legitimate to take into account other aspects of, in this case, the statutory scheme under which the defendant received the payment. And under the UK domestic scheme applicable to dividends paid by UK companies, the revenue was under an obligation to provide tax credits to recipients of dividends in respect of which ACT was payable. So that was the basic domestic position. However, having relied on EU law to deny that ACT was payable, the tax claimants must accept the consequence that the tax credits were not payable. Therefore, the tax credits which were actually provided on the basis that ACT was payable must be taken into account in assessing the enrichment of HMRC. So that's why we say this is a question of enrichment, it's not a question of any kind of defence. There is a subsidiary question raised by the claimants as to how the burden of proof is allocated on this issue. We say it's the normal way that the burden is allocated. The legal burden of proving the amount of the revenue's enrichment, or indeed that the revenue was enriched, always remains on the test claimants. However, they can shift the persuasive or evidential burden to the revenue by proving, first of all, the payment of unlawfully charged ACT. So they establish a prima facie enrichment. The revenue can then shift that burden back onto the tax claimants, by establishing the obligation to provide tax credits as something which reduces that enrichment or nullifies it. Then it's then a matter for the tax claimants to prove that there was an enrichment. And for the reasons set out in Prudential, we would submit a time value enrichment would not avail the claimants. So that is this summary. Would it be helpful? Can I just take you, very briefly, to the legislation, just to show you where it is in context? It's in Authorities Bundle 1, tab 3.
We need the page numbers because we don't
sorry.
paper
I was going to take you first of all to section 14. I'm sorry, my lord. EF 3066. So this is the basic provision which charges ACT, and it's subject to section 247. Section 247, of course, is the provision about group income elections, which was very important in the preceding litigation, including Pirelli and Hurst and DMG. So where a company resident in the UK makes a qualifying distribution, it's liable to pay an amount of corporation tax, i.e. advanced corporation tax, in accordance with subsection 3. What happens to this ACT? We find that in chapter 5, which begins at EF 3086. And section 238 is quite an important section, although it's mainly definitional. It defines a number of important terms: franked investment income, income of a company resident in the UK which consists of a distribution in respect of which the company is entitled to a tax credit, and which represents income equal to the aggregate of the amount of the distribution and the amount of the credit. And franked payment is the amount of a qualifying distribution and such proportion of that amount that corresponds to the ACT. And essentially, subject to some other provisions, the amount of ACT that has to be paid is on the difference between the franked payments made, which are the distributions, qualifying distributions, and the franked investment income received. We'll come on to see that. Then 1A, a company has a surplus of franked investment income for a period if the amount of the franked investment income exceeds the amount of the franked payments. And what happens in that case is that the surplus franked investment income is carried forward to the next period. And then section 239 is the important section about set-off. Advanced corporation tax which is paid by a company, hasn't been repaid, in respect of any accounting period, is settled against its liability to corporation tax or any profits for that accounting period, and accordingly discharge a corresponding sum. So it acts as a set-off against what is called mainstream corporation tax. And there is a possibility of carrying back under subsection 3 certain amounts of surplus advanced corporation tax in certain ways. And I think subsection 4, you see what happens when there is surplus ACT. That carries forward to the next period and is treated as ACT of that period. So once you've paid ACT, there's a number of things you can do with it. First of all, you can set it against your corporation tax for that period. In certain circumstances, you can carry it back. You can carry it forward to set against corporation tax in later periods, or you can surrender it. And that's section 240. Where a company has paid an amount of advanced corporation tax in respect of a dividend paid by an accounting period, it may, under this section, surrender the benefit of so much of that amount as is available for surrender, or any part of that amount that's available to any company which was a subsidiary of it throughout that accounting period. And the company which receives the surrender can then set it against its liability to corporation tax by way of set-off, essentially. And this is something which happens quite commonly, happened a lot in the back group, and is one of the reasons why this litigation was so complicated as a matter of computation to work out what happened to the unlawful ACT. And one of the issues, perhaps the smallest issue, which the test claimants are an appellant on, is asking a question about surrenders of ACT and how they should be treated. The other important thing to note is you can only surrender to a subsidiary, i.e. down the group. You can't surrender to parents or up the group. And this led to the practice, which was that normally ACT was paid as high up the group as possible, because that gave the flexibility to surrender it to all the other companies. It didn't always happen, but 90-odd% of the time, ACT would be paid at the top level company. And section 241, which is on page 3090, that is telling you what happens when they receive franked investment income. And as I mentioned, the effect of that is you're only liable to pay ACT to the extent that the distributions exceed your franked investment income. The purpose of that, the purpose of the franked investment income system, broadly, was to ensure that ACT was only paid once in the group. So if, unusually, perhaps slightly unusually, ACT was paid, at the bottom was company, the dividend which it paid would be franked investment income of the parent company, and the parent company wouldn't have to pay ACT when it then distributed further to its shareholders in respect to the extent of the franked investment income. So the idea was that if you had a single, if you could just imagine the same dividend being paid up through a chain of companies in a group, the effect of the FII system would be the ACT would only be paid once. If it was paid at the bottom, it wouldn't be paid anymore. Now, the other part of the jigsaw is section 247 of the group income election, because that's the other way of ensuring that it's only paid once in the group. And section 247 is on page EF 3114. Now, this provision allowed companies in a group to elect between themselves that any dividends they paid between themselves weren't subject to ACT, and therefore there was no tax charge, and they weren't franked investment income. So the company that received the dividend wouldn't have any franked investment income. The company who paid the dividend wouldn't be liable to pay ACT. And that is, if the court can find what I've called diagram A, which is, this is simply an illustration. It doesn't matter that it is in fact the back group. It's a chart of UK companies. In green, the UK companies are in green. The EU subsidiaries at the bottom are in blue. But the simple point to make is, if you can imagine a dividend being paid from Westminster, which you can see is in the middle, Westminster 1973, 1998, being paid up to Bat Company Limited, then being paid up to Bat Holdings, and then being paid up to Bat Industries PLC at the top. What would tend to normally happen, is that all these dividends would be paid under group income elections until it reached the top company. The effect being that no ACT was paid, but it would mean the top company wouldn't receive any FII, and it would have to pay ACT when it distributed to its shareholders. So that would be the norm. Alternatively, if Westminster paid the ACT at the bottom for some reason, every dividend that was paid up would be paid up with FII, and so none of the companies above it would ever have to pay ACT in respect to the dividend. This is assuming a simple case where the dividend is the same amount. Obviously, in real life, it's more complicated than that, but just to understand conceptually what the idea of this system is. So that the purpose of these two provisions was really to ensure within a UK group that ACT was paid once, but only once. Now, of course, section 247 was the subject matter of the litigation in Hurst and the other cases that followed it. And the complaint that was being made there was that this group income election can only be made between resident companies, UK resident companies. And in Hurst, the UK company with a German parent complained that it couldn't make a group income election with its German parent. And the European Court agreed that that was a breach of the freedom of establishment of the German company, and therefore it was unlawful to deny the companies the ability to make a group income election. Now, of course, the result of this, as far as UK tax is concerned, is that there would be no ACT paid anywhere, because the result of a group income election would be no ACT when it was paid to the foreign parent, and that obviously thereafter no ACT would be payable. And that perhaps leads me on, unless there's any questions about the basic scheme, leads me on to Pirelli quite nicely, because the problem which arose in Pirelli was that While the subsidiary in the Pirelli who paid dividends to an Italian parent, it had to pay ACT. The Italian parent received a treaty tax, what's called a treaty tax credit from the UK under the double tax treaty between the UK and Italy. And the argument in Pirelli, which was one of the test claims in the ACT litigation, was that this tax credit received by the parent had to be taken into account in assessing the compensation available to the subsidiary in respect of the unlawful charge of ACT. And before we look at Pirelli, there's just 2 points I'd like to note about it for you to keep in mind, which you'll see mentioned in the judgments a number of times. What it concerned was applying UK legislation to a situation which could not have occurred under the UK domestic law, and so was not contemplated by the legislation. And that situation was that a dividend paid by a UK resident company without ACT being payable anywhere in the chain. This situation, similarly in the present case, we have a situation where ACT is not payable. The reasons were different. In Pirelli, sorry, in Hurst and Pirelli, the reasons because the group income election was available on the payment to the non-resident parent, so no ACT was ever payable. In the present case, it's because of the unlawful charge to ACT held to be on the redistribution of the EU dividends. But the effect is the same, that no ACT has to be paid. And so in both cases, you have to apply the UK legislation to a situation which simply was not contemplated by that legislation. The second point is that you will note throughout Pirelli that the remedy being considered was described as a compensatory remedy for loss. It wasn't being analysed by the courts, by any of the courts, as a restitutionary remedy, an unjust enrichment. And because it was being looked at as a compensatory remedy for loss, that led to the problem of the two companies. In other words, why were you able to take account of the, if you like, the gain of the parent in getting the tax credit to set off against the loss of the subsidiary? And in the courts below, Mr. Justice Park and the Court of Appeal both felt that that would be improperly piercing the corporate veil, in essence, to take account of these two things, because these were two separate companies. The claim for loss was by the subsidiary, and as I say, any possible countervailing gain was by the parent. But that's why the problem arose, because it was being looked at as essentially a damages claim. And in fact, it led to two different consequences. The decision in Pirelli in the House of Lords, I'm just going to come to, but it led to two consequences, and I just mentioned. One is the ability to set off the value of the tax credit against the compensation. But the second was that it raised a factual question as to whether the election would have been made at all. And that was a matter that was dealt with on a remitter, which we'll have to look at that, perhaps not today, but later on, in relation to some of the arguments about forward and the tax credits there. But what happened was that it was remitted back to the High Court to determine on the facts, would Pirelli have actually made the group income election if it had known that if it did so, its parent wouldn't get the tax credit. That was the question that was remitted back, and the answer, factually in the end, was it wouldn't have made the election. The High Court decided for various reasons. I think factually what happened was Pirelli, when they paid the dividends, believed that they would recover the ACT quite quickly, and there was quite a lot of evidence that that was the case. But as it happened, they didn't, because of intervening circumstances. And so Mr. Justice Henderson concluded that had they been in possession of the facts, the true law, had they understood that they were able to make a group income election, the result would be the parent wouldn't get a tax credit, that they wouldn't have made the election, and therefore there was no loss resulting from the breach of European law. But it's important to recognise that, because what we're dealing with here is not a claim for compensation, but a claim in unjust enrichment. So can I then take you tab 13?
Could you give us the reference again?
Oh, I'm sorry, my lord. It begins on EF 3477.
Thank you.
I think I've probably summarised the background to it sufficiently. It was simply that this was a dividend paid, or dividends paid by UK resident companies to their Italian parents. And the question was, had they made a group income election at the time, had they been allowed to and made one, as European law allowed them, would the parent have been entitled to the tax credit? And a very important step in the argument of the House of Lords in this case was that in a domestic situation, there is a link, an unspoken but a very close link, between the payment of ACT and the obtaining of a tax credit. And we see that first set out by Lord Nichols. This is on page 3479 in paragraph 1 of his speech. And it's just below letter G, where he says, the means, just at letter G, the means adopted for this purpose was that a company was required to pay a tax on its dividends known as advance corporation tax, or ACT in short, and its shareholders were given a corresponding tax credit. Nowhere did the legislation state that liability to pay ACT was a precondition of entitlement to a tax credit, but this unspoken linkage lay at the heart of the scheme, and the legislation was drawn in a form which achieved this result. This linkage is central to the first issue raised by this appeal. And then he goes on to consider what would have happened, how the legislation should be interpreted, in particular the double tax treaty in this case with Italy, how it would apply if a group income election could be made. And if the court would just like to read paragraph 10 and paragraph 11 of his speech, which begins on page 3481. And then, so Lord Nichols says at paragraph 12, so much is clear. The question before the House, however, requires one to inhabit a new and different world, a world where an election dividend may be paid to a non-resident company. How is Article 10 to be read, understood in the new world? And then he says if it's to be read literally, he would agree with the Court of Appeal in Mr. Justice Park. And then he discusses how it might be interpreted in paragraph 13. And then perhaps if the court would just read paragraphs 14 and 15. And can I just also draw your attention to paragraph 19, which is in the context of the second question, where he deals with the question of the link between the payments of ACT and the tax credit, and says particularly just below letter H, at letter H, one consequence is that by making the election, the subsidiary will obtain the advantage of not paying ACT in respect to the relevant dividend. Another consequence is that the subsidiary will obtain the advantage at the cost of depriving the parent of a tax credit. Those two fiscal consequences are inextricably linked. You can't have one without the other. That's why the election has to be made jointly. The advantage of the paying subsidiary comes at a price to the recipient parent. So that's what Lord Nichols said. And then Lord Hope, we just go across to page 3487, paragraph 35. Where he says, just above letter E in paragraph 35, the payment of ACT was not enacted as a condition that had to be fulfilled before a shareholder could become entitled to a tax credit, as Mr. Justice Park was right to point out. But the link between these two provisions, imposing the liability of the ACT and giving the right to the tax credit, could not have been more clearly expressed. And then if you might just read paragraphs 37, 38 and 39 of Lord Hope. And then finally, I just want to take you to Lord Walker. And it's, in particular, it's page 3507, EF 3507, paragraphs 103 and 104. So we say that the fundamental linkage between ACT and tax credits was an essential building block in the argument, in the decision in Pirelli. Was the court then had to go on to consider, in the light of that, whether the parent company could obtain a treaty tax credit, which of course is not a credit under Section 231, but was a special something created by the treaty. And it was decided that in a situation where you couldn't obtain a tax credit in domestic law, that you wouldn't interpret the treaty to allow a tax credit to be available under the treaty because of the way the treaty was worded and its evident purpose. So we say that that's the first step in the argument. The second step is to look at the European law arguments which the taxpayers have put forward. And the first is based on the conforming interpretation of Section 231 to provide what is sometimes referred to as an EU 231 credit. EU tax credit. Now, what is the purpose of that? And I think I can explain this most easily by reference to this, to diagram A, which we have. Now, the problem which arose in relation to computing the unlawful ACT was this. You'll see that the EU subsidiaries at the bottom will be paying dividends to the companies which are immediately above them, which we refer to as the Water's Edge companies, Westminster, Brown and Williamson, etc. Now, those companies, when they distribute on that, will not themselves generally be paying ACT. The ACT will normally be being paid at the level of BAT Industries PLC here at the top when they pay it out to the shareholders. The problem is, how do you link the dividends that are paid by the subsidiaries to, say, Brown and Williamson, and the dividends that are finally paid out by the top company? Because there will be a complicated series of dividends over many years between all these various companies. You can imagine the payments going up. They don't necessarily go up at the same time. They don't necessarily go up in. They don't necessarily distribute all the money they receive. They might keep some of it or reinvest it or whatever. So there's a very complicated factual decision to be made. And the way that the courts decided to do this was to create, and I'll show you what Mr. Justice Henderson said about this, was to create this EU 231 credit when the UK company received the dividend, Brown and Williamson, for instance, and then to trace that through as it is passed up the group under the UK rules, although modified to some extent. And that leads eventually to EU 231 credits being received by BAT Industries. And the effect of that was when they received those credits, they would nullify the charge to ACT being paid by BAT Industries. And so that would determine which ACT was unlawfully charged, because it was only ACT which was linked with EU dividends which was unlawfully charged. There could well be ACT paid which arose from other dividends or other sources, which would be perfectly lawful. So BAT Industries would be paying dividends and would pay ACT, some of which would be lawful and some of which would be unlawful. And so this was all a way of identifying what proportion of the dividends paid by BAT Industries PLC in this example were unlawful and for what period. And all of this was very important because then, having identified those dividends as that ACT as being unlawful, you then had to look and see whether it was surrendered, when it was surrendered, which companies it was surrendered to, etc. So there was a lot of, it was a very important part of the whole process. Can I then just take you to the best explanation, I think, is in Mr. Justice Henderson's judgment, his second major judgment in High Court 2, and it's EF. It begins in EF 1280, but the paragraphs where relevant are at EF 1323 to 1326. It's paragraphs 151 to 155. Yes, you can see it's under the heading, the CT61 method. It's given that name because CT61 was the form on which companies returned ACT when it existed. And so paragraphs 151 consists of an explanation. I don't need to take you through the explanation of how it exactly worked. An explanation as to how the CT61 method worked. And there were various adjustments you can see in paragraph 13.5 on page 1324 that had to be made. And then paragraph 152 says the walkthrough document went on to explain by reference to a number of tables how the EU section 231 credits were passed up the group in parallel with qualifying distributions on which ACT was actually paid, as recorded on the relevant CT61s. Because of course there were actually CT61s and there were actually things happening at the time contemporaneously. The EU credits were then set against the ACT payments, and the element so relieved was identified as unlawful ACT. So that's how you got to unlawful ACT. And then, of course, we had to ask the question, what happened to that unlawful ACT? Was it set off? Was it surrendered? Did it remain outstanding? And the consequences for recovery are different depending on what actually happened. And that was the method that Mr. Justice Henderson decided was the best method, the appropriate method for linking EU dividends with ACT payments. And you can see that on page 1326, just below where you have the C indented, my discussion, just below that he says, I consider the CT61 method provides an appropriate method in principle for linking EU dividends with ACT payments made within the group. My point is quite a fairly simple one. You don't need to understand the CT61 method. My point is that the purpose of the Section 231 credits, and indeed the conforming interpretation of Section 231 to allow for these credits, was to do exactly what Mr. Justice Henderson said. At the level in my paper of, let's say, typically BAT Industries PLC, it was to identify how much of the ACT that company paid was unlawfully charged ACT. It didn't say anything about the position of the shareholders of BAT Industry to whom it made the payments. Can I then turn to the EU law point which prevailed in the Court of Appeal? And if we just take up the Court of Appeal judgment, it's page EF 905. And in fact, the Court of Appeal's decision on this point is all within, I think, paragraph 247. So they say here, in our judgment, HMRC's case is successfully met by Mr. Ameson's principal submission on this issue. He submits that there's no proper analogy with Pirelli. In Pirelli, what was lost by the breach of EU law relied upon was the ability to make a group income election. That meant that no ACT was payable. It followed inexorably from that in such a case, Section 231 meant that no credit was obtained. But here the position is different. The vice that EU law seeks to cure is the failure to treat UK companies with EU subsidiaries in the same way as UK companies with UK subsidiaries. If they'd been treated equally, the ACT and the distribution up to the shareholders would not have been payable. The ACT, because of the EU subsidiary, had paid its foreign corporation tax. But then it's critical, but if the foreign corporation tax is to be treated as UK ACT, then the UK company, by whom the dividend was paid by the EU subsidiary, would have obtained an ACT credit. And that credit would have passed on to the shareholders receiving the ultimate distribution. Thus, the ACT paid in this situation was not properly analogous to the ACT paid in Pirelli, where the double taxation tax credit was a matter of construction inextricably linked with the payment of the ACT. Here, the tax credit granted to the shareholders is properly to be regarded as a matter of EU law, as a quid pro quo, what Mr. Aronson called the reciprocal for the payment of foreign corporation tax at the bottom of the chain by the EU subsidiaries making the original distribution. Now, we say that's simply wrong as a matter of EU law. The Court of Appeal correctly described the comparability exercise which was carried out by the European Court. But it didn't. The conclusion which it came to from that is a wrong one. If we just look at what the European Court did, this is the first reference, which is in Appendix 1B. And I think it begins at EF 1555. And it's the paragraphs 86 at the bottom of 1555, 86 to 91. The court would just want to read that and now submission on it. Now, if the court could just lay their hands on diagram B, which is a much simpler diagram than diagram A. Now, this illustrates the very simple comparison which the European Court was making in the first reference. They were concentrating on a simple situation, comparing the position of a UK company with a UK parent, which is on the left-hand side, and an EU company with a UK parent. And what they were saying was, what the comparison was, well, if you imagine that both of these companies, the bottom companies, UK company 2 and EU company, both paying dividends, the same dividend to the shareholder, and you imagine that the UK company paid ACT, the result would be when UK company 1 received the dividend, it would be franked investment income. And therefore, when it distributed on to its shareholders, it wouldn't be liable to pay ACT. We're assuming, again, for simplicity, that the amounts are the same. However, where the EU company paid a dividend to its UK parent, that didn't carry any FII. And therefore, when it paid to its shareholders, it had to pay ACT. That was the comparison that was being made. So UK company 1 pays no ACT because its subsidiary is a UK company. UK company 2 pays ACT because its subsidiary is a non-UK company, an EU company. Now, the response to that, the revenue's response was, well, they're not in a comparable situation. This was the argument in the first reference, because the UK company pays ACT. UK company 2 pays ACT. EU company doesn't pay any ACT. Therefore, they're not comparable. Therefore, you cannot say that that UK company on the right is being treated less favourably than UK company on the left. Or at least that wouldn't be a restriction. It wouldn't be a discriminatory restriction because they're not comparable. The answer to that, which the European Court gave, was they are comparable because the EU company pays corporation tax in where it's resident. And the UK company, what we're talking about, pays ACT and then possibly corporation tax, which is a future ACT being advance payment of corporation tax. Therefore, they are comparable. What it wasn't saying was, and that's for the purpose of deciding whether there was a restriction in this situation. What it wasn't saying was that foreign corporation tax is to be treated as ACT for all purposes, in all situations. It was simply a very simple response to an argument being put by the revenue in that case as a matter of comparability. So there is no principle in EU law that foreign corporation tax is always to be treated as ACT, and the same as ACT. We would say that's simply a misreading of these paragraphs, a misunderstanding of the argument, and misreading of these paragraphs in the judgment. And those are the paragraphs I think that the Court of Appeal relied on for this proposition. So we say that the sentence which says if foreign corporation tax is to be treated as ACT, then the UK company to whom the dividend was paid would have obtained an ACT credit. If by that they mean a credit under domestic law, then we would say that's simply wrong. Now, what you have to look at is whether a credit would be required for the shareholders in my example would depend on whether not to provide one would be itself a restriction on a treaty freedom. And the question then arises, well, these are situations, is there a situation in the UK domestically where a credit is provided? And is that situation comparable to the situation where the credit is not provided, we say? And to understand that, you have to again look at this diagram, and you can see, if you imagine a situation, the EU company has paid corporation tax. Whether it's paid it or not, it doesn't really matter. The dividend which it pays, the foreign nominal rate of corporation tax will go to effectively nullifying the corporation tax on the dividend to the UK company. So where we have EU company Water's Edge, on a simple assumption that its nominal rate is the same or greater than the UK, the result would be no corporation tax paid on the dividend. The position on the left-hand side is the same. The UK company pays a dividend to the parent. There's an exemption under Section 208, so there's no corporation tax. Providing the credit at the foreign nominal rate is regarded by the European Court as the equivalent to exemption. That's what it says in the second reference. I'll take you to that just in a moment, but that's the basis of its reasoning in the second reference. So that's the same. Similarly, the ACT payable by the UK company on the right would be nullified, again, by the foreign nominal rate of the EU company. So the result would be the situation on the right. There would be corporation tax paid at the bottom, no corporation tax on the dividend, and no ACT on the distribution. That's the position as a result of the application of EU law that we know about. The position on the left, we would have corporation tax paid at the bottom, no corporation tax on the dividend. However, we would have ACT paid either at the bottom or in one of the companies, most likely the top company, but it didn't matter. One of the companies would have to pay ACT. So what we have is you're comparing two situations. One where there's no ACT, but everything else is the same, and the other one in which there is ACT. And we say that is not, as regards the shareholders' tax credits, that is not a comparable situation. for the purposes of EU law. And that's because, as we've seen from Pirelli, the link between ACT and the tax credits is absolutely fundamental to the UK system of providing tax credits. So it cannot be said, we would submit, that paying ACT in the UK situation and not paying ACT in the foreign situation is an irrelevant fact. It is absolutely fundamental to the way in which the imputation system, the partial imputation system, worked in the UK. And you can find that. I've already taken you to a number of these paragraphs, but I can just give you references in Pirelli to the paragraphs in which the court stated the fundamental nature of the link between ACT and the tax credits. It was paragraphs 1, 15, 19, 35, 37, 39, 68, 70, and 103 to 105. As I say, some of them I've shown you already. So we say that there simply wouldn't be a restriction on any treaty freedom if in the situation on the right-hand side, no ACT is paid and no shareholders' credits are received. On the left-hand side, ACT is paid and shareholders' credits are received. Perhaps I can just take you briefly, as I said, to that passage in the second reference, which talks about credits at the FNR. It's again it's Appendix 1B, and it's page EF 1653. And it's paragraph 60 to 64, but in particular, paragraph 61 and 62. So, just to clarify, in case this isn't completely clear, that the foreign nominal rate credit operates at the full foreign nominal rate, whether or not any tax is paid in the foreign country. It's nothing to do with actual tax being paid. So you're obtaining a credit literally for the nominal rate of tax, which is why it's said to be equivalent to exemption, because of course you could have a situation where the UK company doesn't pay any, trading company 2 doesn't pay any tax, but the dividend is still exempt when it's paid to UK 1. So these are the reasons why we say there's no breach of European law in not providing a tax credit where there's no ACT paid. And that moves us, I think, on to essentially the domestic law issue as to whether where a taxpayer pays a sum of money by way of unlawfully charged tax to the revenue, whether in determining the enrichment or otherwise of the revenue, it is legitimate to take account of requirements that the revenue have to provide tax credits to the parent company of the company paying the unlawful tax, or to the shareholders, I should say, rather than parent company, to the shareholders. And we would suggest that there is a useful analogy on this issue to be found in the case of ITC. And I think, in fact, the Court of Appeal found that helpful. And if we could just turn up, ITC is in Authorities Bundle 4. It begins on page EF 4644. I'm sorry, I'm taking you initially to Mr. Justice Henderson's decision. And I think I can explain the facts for those who have not seen this case before, actually most helpfully from the diagram, which is at the end of his judgment at EF 4706. And if we look at diagram 2, so what the case concerned was investment management services provided by the investment manager in the middle to the investment trust company. And the simplified assumption being made is that at the time they were made, everyone believed that the supplies were standard rated for VAT, so they were subject to VAT. And so the investment trust company paid £100 in this assumption by way of VAT to the investment manager. It was then discovered, because of a case in the European Court, that these services should have been exempt. Therefore, no VAT should have been paid or charged, and nothing should have been accounted for to the revenue. The investment managers were able to recover VAT for certain periods, but there were some periods that they couldn't recover it and the investment trust company sought to try to recover it directly from the revenue on the basis of unjust enrichment. As you can see from the middle of the diagram, the investment managers, in fact, accounted for £100 of output tax on their VAT return, and then claimed £25 of input tax in respect of their own supplies that they had received, that they had paid for. If you look to the left, to their suppliers, so for overheads and things which were used in making the taxable supplies. So they had £800 of output tax and £25 of input tax claim, and they, of course, they paid the net amount of £75 to the revenue. Investment trust company was seeking to recover the full £100 because they paid £100 of VAT. It was accounted for by way of output tax to the revenue, and they said they should recover it. Now, there was obviously an important issue as to whether they could recover at all, and whether anything, I think again, was at their expense, essentially, whether an indirect claim like this could succeed. However, there was a second issue, which was even if it could succeed, what was the correct enrichment of the revenue? Was it £100 or was it £75? And Mr. Justice Henderson decided, well, he decided first of all, he decided that they could make this claim in principle, but he also decided that the enrichment was in fact £100. And you can see his discussion of the enrichment beginning at paragraph 40, which is on page 4661 in this report. And if you turn across to 4663, paragraphs 44 and 45, and just perhaps read those. These are the reasons why you rejected the argument that you should net off the £25 input tax. There is a point to note which I didn't mention that you may not be aware. If the supplies were in fact exempt, which they were held to be by the European Court, the investment managers wouldn't have had any rights to recover input tax. That's the key point. So Mr. Justice Henderson took the view that the revenue were enriched by the full 100 because the 25 was being paid essentially to the investment manager as its claim for input tax. However, the Court of Appeal, which you'll find in the same volume at tab 51, the following tab, beginning at page 4707, they disagreed with this enrichment analysis. They in fact agreed with Mr. Justice Henderson that there was a claim, an indirect claim could be made, but they disagreed with what he said about enrichment. And their discussion of that begins at paragraph 26. But in particular, I think if you pick it up at paragraph 37, which is on page 4721. You just read paragraphs 37 to 40. And then could I take you then finally to this court's decision, which is in volume 1. It begins on EF 3371. And the enrichment discussion starts at paragraph 25. And which is on page 3387. And if you just read what the court said, there's no dispute that the commissioners were enriched to the extent of the notional £75. What is in dispute is whether they were also enriched to the extent of the notional £25, which they didn't receive. The judge held that they were. Although the £25 was not paid to the commissioners by the managers, it enriched the commissioners, in his view, by being set against the input tax which the commissioners would otherwise have been obliged to pay or credit to the managers. That is to say, the tax which the managers had paid on the goods and services supplied to them for the purposes of their business of supplying investment services. The Court of Appeal considered this reasoning to be fallacious on the basis that if the supply of services by the managers was not taxable, then the managers had no right to deduct as input tax the VAT which they had paid to their own suppliers. The managers retained the notional £25 in satisfaction, which the court regarded as a purported obligation on the part of the commissioners which never existed. The commissioners did not therefore benefit from the lead claimant's benefit payment of the additional 25. An order compelling to pay that amount, the lead claimants would not reverse an enrichment but leave them worse off, having received £75 and made restitution of 100. We would say that there's some analogy in this case, because in this case we would be in the situation that the revenue would have paid out the tax credits, which, on the true view of the law, they wouldn't have been obliged to do so. That is the premise on which this argument is based, because the ACT charge, because the ACT was not in fact payable. And in fact, in the Supreme Court, the claimant's argument was based really on a timing point, I think, or on the question, on a point that although they weren't obliged, sorry, they weren't entitled under European law input tax, they were entitled under domestic law at the time, but that was rejected by the Supreme Court, and it was held that they were commissioners in paragraph 30 were not enriched by the manager's retention of the notional £25, and the managers have in principle no defence to a claim by the lead claimants for the restitution of that amount. The lead claimants' claim to restitution against the commissioners proceeds on the basis that the supplies which they received from the managers were exempt from VAT. That being so, it would be surprising if they could present that claim in relation to the measure of restitution on a basis that was predicated on the supplies being taxable. And we would say the same in the present case, that they cannot present the claims on the basis that claims to recover via ACT on the basis it wasn't payable, but at the same time expect that the revenue, the revenue having paid tax credits to their shareholders should not be able to take that into account in assessing the amount of the enrichment. In this case, in assessing the enrichment of the remember it's the in this case it's the enrichment not of the managers we're talking about, but the enrichment of the investment fund. Sorry, the enrichment as against investment funds, and taking account of that. In this case, you were taking account of VAT credits given to the managers, which shouldn't have been given. These are not credits being given to the investment trusts themselves. So it doesn't matter, we would submit, that the statutory scheme results in the payments being paid to someone else, in this case, the managers. In our case, the shareholders. It's still legitimate to determine the enrichment of the revenue by looking at the entire, their obligations under the entire statutory scheme, and not simply looking at the receipt of the cash, which is what the test claimants would like you to look at. The test claimant's proposition appears to be that a receipt of cash is simply an enrichment and that's the end of it. But we say that isn't correct as a matter of principle. There are many examples, and we've listed a number of them in our written case. The first written case in paragraph 79, I don't know if I'm not proposing to go through all of these, but there are a number of examples given of cases in which there's a receipt of money, but that is not regarded as being an enrichment of the recipient. One example that my Lord Sales might be familiar with and might remember is a case called Jeremy Stone's Consultant and NatWest Bank. That was a case about a Ponzi scheme where the parties who were defrauded only discovered it after the fraudsters had spent all the money, pretty much. And so they sued NatWest Bank on various grounds, including unjust enrichment. And the point was made that although NatWest Bank received the money and received it beneficially, and it became its money from the fraudsters, it received it subject to its obligations to the account holders under its contractual obligations, and therefore it wasn't enriched by that money. That is another example where, although the party receives the money and receives it in fact as their own money, there are further complications because of the arrangements which are around it, which mean that that person is not enriched. Other examples are agency cases, which we cite in paragraph 79. And indeed the Vodafone and Office Communications case, where the proposition was that the public body was not enriched by the receipt of sums which could have been lawfully charged but weren't under the legislative regime in question. So we would say that there is plenty of authority to support the proposition that a payment of cash in itself doesn't necessarily enrich the recipient by the amount of the cash. So that is all I was proposing to say at present about issue 17. We then have issue 18. This issue arises on the assumption that the application of the English law of unjust enrichment would lead to the conclusion that the revenue are not enriched, and so the tax claimants cannot recover restitution on a claim in mistake. They can recover, we would submit, on a claim for repayment under principle of Woolwich. And we set out the reasons.
Mr. York, Lord Hodge has a question for you.
Lord Hodge, yes.
Before we go there, I just would like to have something clarified. Your argument now is that EU law does not require a tax credit to be given in order to achieve equality between the exemption method and the imputation method. Correct?
To shareholders in the situation we were talking about, yes.
Yes. Which provision of the of ICTA has to get a conforming interpretation to achieve that result?
Sorry,
Have I misunderstood?
Might be the other way around. I think if a tax credit was required by EU law,
yeah,
the test claimants would have to identify a provision of.
No, but in order to achieve equality between the exemption method and the imputation method, something has to be altered in domestic law. You say it's not the tax credit. What is it?
Well, there are two things. If we're looking at corporation tax, Manor, because there are two elements to this. If we go back, corporation tax charge on the UK company is negated by the exemption if it's received from a UK company. So going back to my diagram on the left, a conforming interpretation has been given by the courts in situations where an EU company pays a dividend to a UK company. A conforming interpretation has been given which grants a tax credit against corporation tax for the UK company at the foreign nominal rate. And I can't remember which provision was actually it was given to, or whether it's been set out, but there's no doubt that that is a conforming interpretation that was given. I think it may be section 795, which I think is a double tax treaty. It's one of the double tax treaty provisions. That would remove the corporation tax charge or solve that problem. As regards ACT and the problem that I was alluding to between the discrimination between not receiving FII and receiving it, that is being solved, if you like, by a conforming interpretation of section 231 to grant this, what I called, what is being called the EU 231 tax credit, which has the effect that the UK company, in my example, in my simple diagram, the UK company above the EU company doesn't have to account for ACT. It's not payable on the dividends it pays. That has the effect. The effect of that is to nullify the ACT charge on the shareholders. But it doesn't have anything to say. Sorry, the ACT charge on the UK company on its dividend to the shareholders. It doesn't have anything to say about the position of the shareholders in my diagram. Is that? I don't know if that helps.
I just wanted clarification as to what your position now was. Thank you.
Yeah, I'm slightly worried that you see my position now was. I don't think our position has changed on this, as far as I'm aware.
Is that right?
Yes, I don't. Well, sorry. I'm sure during the litigation we have been disputing the terms of the conforming interpretation in the computations, if that's what you're referring to. There's no doubt about that. Yes, but that's all been decided now. I mean, I'm taking as a starting point the decision of the Court of Appeal upholding Mr. Justice Henderson on these questions. I'm assuming that's the law. That's where we stand. So yes, if that was what you're referring to, yes.
So you say that one has to have a conforming interpretation of section 231, but that has no effect on giving a credit further down the line because you simply take the European dividends out of the ACT charge.
Further up the line, I think, possibly.
Or further up the line. Yeah.
Yeah. Yes, that's right. Yeah.
Thank you.
So, sorry, issue 18.
Just one more question, Mr. York. This may sound a very basic question, but I just want to be clear in my own mind. Does this mean on the right-hand side of your diagram B, in a conforming arrangement under which the foreign company's dividends are not effectively, when they're passed up to shareholders and not made subject to ACT, that the shareholder therefore has to pay tax on the dividend which the shareholder receives without any tax credit at all?
Is that, yeah, that's the UK company, yes. Yeah.
I mean the shareholders of the UK company.
Yes.
Your row of shareholders at the top of your diagram.
Those who are paying tax, yes. Many of them won't be.
Yes.
Yeah.
No, I appreciate it's those who are paying tax. Yeah. Thank you.
Yes, because sorry, because one of the big groups of shareholders, of course, are those who recover the tax credit, which is important. The shareholders of these companies are very often pension funds or whatever who recovered them in the past. So issue 18 arises on the assumption that we're right about the English law of unjust enrichment. And it leads to the conclusion that the revenue are not enriched in this situation. And as I was mentioning, they can recover unlawfully levied tax under Woolwich, and we've set out the reasons. I'm not going to go into that now because of the time, but we set out the reasons at paragraph 35 of our second written case, which is EF 471 to 473. Now, the important point to make, I think, here is this is not the same issue which was before this court and the Court of Justice in the first stage of these proceedings concerning the lawfulness of section 320 and 107. The premise of that debate was that there was a claim in mistake available under English law to recover unlawfully charged tax, and that was taken away by the section 320 or section 107 overnight. The claim was there before and ceased to be there afterwards. Today, what we're considering in issue 17 is a different question, whether there ever was a claim. And we say enrichment is the essence of an action of unjust enrichment. That doesn't require any authority, but in fact some does exist, which we've set out at paragraph 83 of our first written case. And we're not dealing here with a defence. And it's for the English courts, the national courts, to determine the nature of the remedies available. And we've seen that in the paragraphs I drew your attention to this morning in the first reference, CGAU 1, paragraphs 201 and 203, which are on EF 1569. We would submit it does not infringe EU law or English law not to provide a remedy in mistake in these circumstances. The same principles apply in a wholly domestic context, and therefore there's no problem about there being any difference between EU law and claims and English law claims. The important point, as I said, was in the first set of proceedings that the argument was about whether claims which existed could be taken away. And you can see that if we turn up the judgment of the Supreme Court the first time, which is in Core Volume 2. And I think we can see it most succinctly in Lord Hope's judgment, which is on EF 1146. Paragraph 16 at the bottom of the page. He says, on the primary issue, however, like Lord Reid, I agree with Lord Walker. I would take as my starting point the fact that in domestic law, two types of restitution remedies are available, and that the taxpayer is entitled to take advantage of the remedy that's most advantageous to him. A claim for restitution of tax unlawfully demanded under Woolwich, and the claim for tax paid under a mistake of law in DMG. And then he goes on to talk about the fact that DMG hadn't then reached the House of Lords. And then paragraph 20 on page 1148. The crucial question, however, is whether the retrospective application of the limitation period claims based on mistake was in conformity with the principle of equivalence and effectiveness, as explained in the Grand Chamber. I accept, of course, that the Woolwich remedy on its own was an effective way of vindicating the San Giorgio right. But what about the principle of equivalence, which, as Lord Reid points out, is a complementary requirement? The Woolwich remedy was not the only remedy in domestic law, as it was held in DMG that a taxpayer who wrongly paid tax on the mistake of law is entitled to a restitutionary remedy against the revenue. The theory is that judicial decisions must be taken to declare the law that applies to the case with retrospective effect, whatever the events that give rise to the claim occurred. So in the events that have happened, the DMG remedy must be taken to have always been available. It's not just a mirror image of the remedy that's afforded in the Woolwich. Both remedies lead to the same result, but they are different remedies. I would say that those words can be very aptly applied to this situation. If this court were to decide that there was no enrichment in this situation, then that would retrospectively apply to wherever the claims occurred. In other words, there would be no question of the court taking away any remedy or anything which a taxpayer already had or claimant already had. It would simply be deciding what the law has always been. And that's not a problem as far as EU law is concerned. You can find the same points made in the judgment of the European Court at Appendix 1B, and it's EF 1689. And it's paragraphs 40 to 43. And you can just see in paragraph 43, just a summary right at the bottom, just above letter G, Such legislation makes it impossible in practice to exercise a right previously available to taxpayers to recover tax paid but not due. Therefore, the national legislation must be considered incompatible with the principle of effectiveness. So what the court was dealing with there was a situation where the claims existed and were then taken away from claimants by the legislature. I have, I think, reached, I hope, the end of what I was wanting to say about issue 18. Again, unless the court has any questions.
Can I just check that I'm following in relation to issue 18? The argument, as I understand it, is that the DMG remedy, that's to say, restitution of money paid under a mistake of law, depends on enrichment, and for the reasons you've explained, you say there's no enrichment and therefore no such remedy. But the Woolwich remedy, as I understand, it's not really terribly elaborated, but as I understand it, it's a remedy which is not dependent on enrichment. It's dependent simply on the receipt of unlawfully levied tax, and gives rise, perhaps for constitutional reasons, to an obligation to repay to the taxpayer, regardless of whether there was enrichment or not. Is that
yes,
right?
That's right, yes.
The existence of that second remedy suffices to meet the San Giorgio obligation.
And yes, yeah. For the reasons we've set out, policy and constitutional reasons. Yeah.
Yeah. Thank you.
There, I think that's perfect timing.
Very well then. We'll adjourn there for the day and resume at 10:30 tomorrow morning. Thank you all very much.